The topic today is the third country provisions. Now, what was interesting for me when these provisions were made is at the time my client base was predominantly foreign, non-EU. It was mostly United States fund managers. And of course, suddenly these provisions became very, very relevant. Now, I say at the outset, and I'll say it very quickly and move on, then we were only concerned about third country provisions for our US clients. With all the talk at the moment in the United Kingdom about wanting to leave the European Union, suddenly a lot of these provisions are becoming a little more relevant, and we in all seriousness, look at them a lot more closely. I've already mentioned or begun to touch on the fact about variable rules for variable firms. But one of the points that I want to pick up today, and I apologize for going outside of my brief somewhat, really are around the inconsistencies, particularly around the MiFID II third country provisions, and those, for example, with respect to AIFMD and other certain contradictions right across these directives, and showing how in practice actually the third country provisions may make the provision of certain types of services, particularly on the buy side, a lot more difficult to actually navigate and work out. But just to go through the agenda very quickly, and I note that we have, I think, just looking at the time, just over half an hour to get through this. Fortunately, it's not a big topic in terms of actual material, so I can be fairly quick. But the first point I want to make is really just to focus on the differentiation between the two types of third country provisions, and the fact that the actual client classification becomes a very important point to note. In essence, this distinction between cross-border services that are provided to per se professional clients and eligible counterparties versus another set of requirements when it comes to elective professional clients and retail clients. And one of the first times that one actually sees a dichotomy being drawn within the professional client classification. I then also want to say something about the non-applicability. I use the words in brackets avoidance, because avoidance often has very negative connotations, around reverse solicitation. This is a fascinating concept. And again, for those of us who have been working under AIFMD, a very central part of the advice that we seek to give. And then finally, I want to bring it back to talk about this interaction with the AIFMD. And I apologize in advance for the buy side or fund management bias on this. But one of the more fascinating aspects of MiFID II, of what it has failed to do in the context of AIFMD. And we talk about remuneration rules. Very interesting that when you look at the remuneration guidelines under UCITS 5, you actually see ESMA beginning, or I think on instruction from the Commission, being told to start to look at these rules more in conformity with each other. So when you're looking, for example, at UCITS 5 remuneration rules, try and do so in a manner that is consistent with AIFMD remuneration rules and indeed MiFID remuneration rules. And the reason that in the buy side in particular this is so important is that if you take, for example, a fund manager, that fund manager wants to deliver a particular investment strategy or return to its clients. It has a number of options. And the main option, certainly within the asset management space, or main choice, is do you bring that client into a collective vehicle, whether that's a UCITS fund or an AIFM, or do you instead say, I will manage your money separately, the so-called segregated mandate? And the reason that is so important, notwithstanding the investment have the same risks, the actual technique that the investment manager or asset manager is applying is identical, is that whereas that collective investment vehicle, investment undertaking, to use the Eurospeak, is governed either by AIFMD or UCITS, that segregated mandate is governed by MiFID. And therefore, all of the rules that apply to MiFID will apply to the segregated mandate. All of the rules around AIFMD use apply. Now, where you have difference between these two sets of rules, for example, around remuneration, the applicability of regulatory capital requirements and the like, then suddenly the difficulties arise. And as I'm going to come to talk at the very end, where you have a situation whereby your third country rules for under the AIFMD and those under MiFID II are different. Even the concepts are different. The regulators are different. This creates uncertainty. And my one takeaway that I'll leave at the end, and again, you may come here just expecting to talk about MiFID II, is to say it points more and more towards the need actually for a consolidation of all the rules governing asset managers under a single portfolio management directive. And I always get shouted down by clients that said, no, we don't want more law. But no, rather taking all this confusion of rules and bringing them into one place. So that's for the end. But in the meantime, I better get to business and actually talk about the provisions themselves. First point up is when we talk about third country service providers and how that is relevant, what we are really talking about in essence is a situation whereby you have an investment firm that does not have a permanent establishment within an EU member state, but wants to offer services to a client who is located in an EU member state. And I'll pause there to say something very, very important, because territoriality still becomes a very important feature. And I contrast the EU approach, say, with the US approach. My colleagues and friends who are US attorneys, they get very hung up about the nationality of a client, that a lot of the US security laws will apply where business is being done for a US person. And now the business may be done halfway across the world, but the fact that there's this US nexus will often make a otherwise unregulated entity subject to US regulation. Happily, under the EU approach, it is still very much a case of actually going in and at a very basic level, actually soliciting, talking, marketing to, and then providing services to an individual who is located within an EU member state. So I think it's very important to understand what we're actually talking about when we talk about the third country provisions. Now, currently, MiFID does not address third country investment firms. Rather, that is left to each member state to determine. And each member state will have various sets of rules. In the United Kingdom, for example, we have what is known as the overseas persons exemption, but subject to certain requirements, provided the service provider is located outside of the United Kingdom, it does not need to be authorized by the Financial Conduct Authority or the Prudential Regulation Authority, as the case may be. Now, interestingly, in consultation, or rather discussion, the UK Treasury, talking about the implementation of the MiFID II third country provisions, has indicated that it would still like to maintain the third country provision, the so-called overseas persons exemption, on a transitional basis at least. But I mentioned at the outset this taxonomy, if you will, around the way that the third country provisions will operate. And there's this distinction drawn, as I say, between services that will be provided to eligible counterparties and per se professional clients on the one hand, and then those that will be provided to elected professionals or retail clients on the other hand. Taking a further step back or forward, in the first case, it is MiFIR, the Market Financial Instruments regulation, that governs that occupies the field. And I'll come on to explain why that's the case, whereas in the latter case, the provisions are actually in the recast directive. Now, and for those of you that like article numbers, in MiFIR it's articles 46 to 49, and in the recast directive 39 to 43. I've avoided putting any article numbers on the slides so people are not distracted. But an important point, I think, to note around this is that the original proposal was that any third country firm wanting to offer services to retail clients or electives would have to come and set up a branch in a member state. No exception, and that branch would be subject to the MiFID II requirements. That requirement has been removed, but instead what you have is almost a type of voluntary regime, which I'm going to come on to talk a bit about. Just to talk a bit about the timing of the third country provisions, because I think this is important. The effect of the MiFID third country provisions is that they are delayed for 3 years, and this is after implementation, because there has to be an equivalence decision made by the Commission on the third country. During that transition period, the member state rules may apply, and that's why, for example, this overseas persons exemption in the United Kingdom and other similar rules is quite important. However, the MiFID II branch provisions will come into effect from the effective date for MiFID II. Now, one thing that I want to note here, and I think it's important, and our experiences under AIFMD really bore this out, there's nothing to stop member states from imposing national rules requiring a third country firm to establish a branch. But the gist of the MiFID II is that if the member state decides to do that, it has to do so in conformity or in compliance with MiFID II. And actually, on that, I'm going to jump ahead two slides just to talk about this right away before I then go back to talk about MiFID. But the idea is that as a member state, you may simply take, the member state may take the view that actually they're content for overseas investment firms to continue providing services to for example, to elected professional clients, high net worth individuals, and therefore simply hold that we will not impose a branch requirement. It seems unusual in the context of retail financial services, properly so called, but there is that option. If the view is simply taken, we are happy, we think that there's a vested demand, maybe there's an insufficient supply of local services being provided for that to happen. But what the directive says is that if you choose to impose a branch requirement, then you have to do so in conformity with the requirements under MiFID II. And these are essentially set out fairly straightforwardly. The first point is the third country firm has to be authorized in its home member state. Again, no surprise there. There has to be cooperation arrangements between the host state and the investment firm's home member state, including information around tax matters. It is important for the branch to comply with regulatory capital and senior management requirements, again, similar to those that Rick was talking about. And then there has to be investor compensation scheme membership. Again, a key aspect of any retail protection regime is that firm pays its dues to the local compensation scheme, and there can be a payout in the event of its failure. There are additional ongoing requirements around organization requirements, conflicts of interest, consumer protection, typical requirements that you would expect to see if you were let's say a full scope MiFID investment firm authorized under local regulation. And this gives rise to an interesting question. But firstly, just worth mentioning that there is a limited passport for a branch that sets up. That passport is the ability to offer services not to retail clients or elected professionals in other member states, but only to eligibles or per se's. And the reason for that is it ties back into the permission that one would have under MiFID. But the question that the directive throws up, and I would suggest doesn't answer, is whether there's a material difference between a third country investment firm that sets up a branch as against the same organization that simply sets up a full subsidiary authorized under the rules implementing Article 6 of MiFID. It's not clear as to whether there's a distinction with regulatory capital, whether there's a distinction with the rules that are applied. Now, the difference between a branch and a subsidiary is often of more relevance in the context of insolvency law than it certainly does under regulation. Interestingly, in certain overseas jurisdictions, I used to do some work in the Middle East, and some of the regulators in the financial centers in places like Dubai and Qatar took the view that if you could demonstrate that you had a lead regulator, say in a recognized jurisdiction, then they wouldn't be responsible for your prudential regulation. Interestingly, it was almost like the equivalent of a passport. There's no suggestion around that under MiFID II. The directive doesn't say that if, for example, you as a US bank are subject to oversight by the Fed and subject to SEC registration, that you won't have to comply with our regulatory capital requirements, or you'll have lesser regulatory capital requirements. And this invites the question, which I'm going to come on to talk about really what the real advantage then is to being a third country branch versus a third country subsidiary, given that you have a limited passport. if you have a passport as a subsidiary, there's none of this restriction about not being able to offer services or on a cross-border basis, or indeed set up another branch, including retail investors. But again, it's not absolutely clear. If anyone has a view on that, I'd be happy to take it. Now, going back to the services under the regulation, this is a innovative and new and very interesting mechanism, and there is a significance as to why this provision has been placed in MiFID and not in the directive. Because I would suggest that the effect of this is to say that the general position is that the directive will apply, the member state requirements will apply, unless a third country firm is able to or chooses to actually comply with the MiFID requirements and become registered with ESMA. And this is another innovation. For the first time, I mean, outside of oversight of credit ratings agencies and some of the information repositories, but for the first time, the Commission has actually given ESMA a licensing competence. And in many respects, it's a very elegant solution. I compare it now back to AIFMD, where there's a concept of a third country, a third country passport, an ability for a third country AIFM to have a member state of reference, where they simply have a legal representative. But here, the Commission is actually saying, no, you will go to ESMA, and you'll get registered with ESMA. Now, that's the good news. The only other point is that the effectiveness of this provision will be determined, firstly, by the need for a Commission equivalence decision. Very controversial area, equivalence. We've already seen it under AIFMD, where I've had to say to some US clients that, well, the Commission thinks the Channel Islands are fine, but they still have doubts about the United States, and the process goes on with trying to determine that equivalence. But the essence of the equivalence decision is that the Commission will need to be satisfied with the third country member states' legal supervisory framework, its process for getting firms authorized, supervised, rules around regulatory capital. The important point that it has to be equivalence in effect rather than being equal. But of course, there's a lot of discretion for the Commission. So the first point off is before any third country can say, well, this is great news, their own regulatory system will have to be signed off by the Commission. It'll also be important for there to be home state authorization. Again, I think that's a pretty obvious point. And there will still have to be ESMA and home state cooperation arrangements in place. Again, these cooperation arrangements are already in place under the AIFMD. It's likely they would draw on the same ones. Now, in terms of the other requirements, these requirements, on their face at least, don't appear as onerous as those for the third country branches. The first is there must be very clear investor disclosure that the only clients that may benefit from the services are the eligible counterparties or per se professional clients. There must be submission to the jurisdiction of the local courts. And again, I understand this is what I'd call a Swiss innovation, that if you're going to market a fund in Switzerland, even if you don't have to come authorized, you at least have to have a local process agent. And it makes sense that if an investor wants to actually sue someone for bad services or advice, they don't have to go to their home jurisdiction, but essentially can do it locally. Now, the effect of this, and this is important, is that a member state cannot impose additional requirements on the entity that's been registered under ESMA. And again, that's quite innovative in a sense, in that if a third country firm can go directly to ESMA, they can then say to all member states, ESMA's happy with me, let me in. And then the other point is that this also gives an effective passport, limited, of course, to the per se's or the professional clients. One of the points, however, on this, and this is a point that we make particularly to US clients generally, is what this does mean, however, is that a US firm, forgive me, I've gone about US firms, those are a lot of clients, would then have to comply with MiFID and the MiFID requirements. It's very difficult to see how there could be any other way of doing so. And I think what needs to be thought through then is that is that a case whereby you then choose which member state has implemented the rules and complied with those rules, or whether you do so on a case-by-case basis, which then really casts doubt over the passport. So there, it seems in my mind anyway, that there's still a little bit of uncertainty. But just touching on this, the concept of reverse solicitation, and again, those of you who work or have worked under the AIFMD will be familiar with this concept. But in essence, where a third country firm can demonstrate that an investor has approached it on its own exclusive initiative, and the language is actually more strict than it is under AIFMD, then there'll be no need to have to become registered or otherwise comply with the MiFID rules. Both the recast directive and MiFID do make it clear that you cannot rely on the first approach that was made to you by an investor to then offer additional services and products. And that's quite an important clarification. And the other point that is important is the recitals to both MiFID and MiFID suggest that there's still this distinction between providing a service and offering a service. And this is one, again, that arises under AIFMD, whereby if you make a mere promotion or market a fund, and I use the term market not in the AIFMD concept, in the general concept, that will not trigger AIFMD compliance. What marketing on AIFMD means is actually giving somebody a prospectus. And there was a lot of controversy around the time that AIFMD was being implemented, because the argument arose was that if I had marketed a fund before the AIFMD came into force, could I rely on an argument that actually my marketing started before? And this term marketing became very important. Actually, it was in the context, I think, firstly of the BaFin, giving a very clear and rigorous explanation that we were able to push some of our German colleagues to say, but doesn't that mean that if you did something that if you do something that is less than marketing, that AIFMD doesn't apply, which people sort of had to nod. It's a similar approach here, that the mere marketing of a service may arguably still be subject to local member state rules, as is currently the case. It's only when you actually now say, great, I now want to bring a client on and actually start providing the service, that the MiFID II provisions will bite. It's a slight subtle and nuance. My only broad comment about reverse solicitation, I'm sure those of you that advise, is that it is a very elusive concept. In fact, when we talk to clients, we say we're not giving legal advice on reverse solicitation. It's more about how you manage your risk. I know, speaking to certain French lawyers, I said it's wonderful. They say a very Cartesian approach, which holds that provided you don't mention your fund, and then somebody asks about the fund, that's not reverse solicitation. And we found the right French lawyers who were very confident, and I said, that's fantastic. And actually, the CSSF in Luxembourg came out with some guidance recently, which was veering in the same direction. The Financial Conduct Authority, in keeping with a good, vague common law approach to things, are not quite as unequivocal about it. But it is a very difficult concept, and ultimately it does come down to the particular risk profile of the firm. I've almost got to saying, if you draw an x-axis and a y-axis, on the one axis you put the number of investors you want, on the other axis you put your own individual appetite to risk, and then you apply a multiplier determined by the enforcement appetite of the particular regulator. If the general distribution is that part of the graph, don't do it. If it's down near the corner, you'll probably be okay. But that's not a very jurisprudentially sound approach. It is more about risk. But to talk about the impact on the AIFMD, and I come back to this question that I raised at the outset about the manner in which you deliver this investment return. Do you do it in a fund, or do you do it in a segregated portfolio? Because the AIFMD, like the UCITS directive before it, acknowledges the ability of a fund manager who authorized under AIFMD or UCITS to also offer segregated mandates. Again, if you go and look at Article 6.4, I think it's 6.5 in the various directions, you will see that if I want to also be able to offer an individual client the same thing, I'm able to do so without having to go off and set up a separately regulated MiFID entity. Now, the issue that arose before, and I'm mixing these two slides up, was that there was a lack of certainty under the AIFMD about the position of an AIFM to passport its segregated portfolio management services. Absolutely clear that if I am established as a fund manager, say here, also over the border in Luxembourg, and I will be able to offer my fund management services throughout the EU, and I can go to Dublin and say, I'll be able to manage your fund on a cross-border basis. It was less clear with respect to the portfolio management services. Now, the UK Financial Conduct Authority said their reading of the directive was that was allowed. The Commission said, no, our reading of the directive is it's not allowed. So there was lack of clarity. What MiFID II has done, as Article 19, is actually to amend the AIFMD and make it clear that if you are an AIFM, an EU AIFM, you can offer segregated portfolio. Yeah, the managed accounts. That's it, managed accounts on a cross-border basis. And that was seen as very good news and a clarification of the position. The difficulty, however, is that either by oversight or deliberately, it has not extended the same privilege to any AIFM authorized under Article 37. And just to remind you, that is the part of the AIFMD which allows a member state to authorize a third country AIFM. And this is where the problem arises. Because if you are now a third country, let's say a third country manager doing funds, doing managed accounts, you get set up, you say you nominate, say, Luxembourg, Germany is your member state of reference, you have your legal representative here, you comply with all of the requirements under the AIFMD. It means that you can then offer your funds throughout the EU, you can offer your fund management services, but you cannot, under your AIFMD passport, offer the managed accounts. What it means is that you will have to rely on the MiFID third country provisions, or if you're also looking, say, to attract high net worth individuals, still within the professional client definition under AIFMD, you would then have to set up a MiFID subsidiary to do that. And that gives rise to what is ostensibly a conflict. There's a further point as well around a lack of harmonization. MiFID limits itself to per se professional clients. And actually, in practice, that's not a bad thing, because even under AIFMD, when people have said, well, we want to be able to market to elected professional clients, they run into this dilemma, and that is that in order for somebody to be an elective, they have to elect before you can market to them, and that's not the way the world works. In some respects, that whereas the position under MiFID may be less broad, it's a lot more practical, because you either are in or you're not. But the problem that a lot of this gives rise to is that there is a lack of harmonization. That you find yourself in a position whereby, notwithstanding that you're delivering the same investment return, if you do it in a fund versus doing it in a managed account, there are different sets of rules that apply. And I think an interesting point to look forward to is to see, first of all, how AIFMD 2 will be amended. And one of the reasons, certainly for fund managers, that they're interested in MiFID II, even if it doesn't apply directly, there's still an indirect application, of course, through product governance, is what impact that's going to have on AIFMD, similarly on UCITS 6. And again, the questions even around remuneration. You have this rather odd position that within that composite asset management firm, your remuneration rules for the fees you charge in your funds are different to the remuneration rules for the managed accounts. And indeed, CRD4 can apply to those parts of your business. So I think overall, the third country provisions, they do bring a lot of certainty, I think, with respect to MiFID firms properly so called. Where there's more lack of uncertainty, and where I think there's probably an increasing need for lawmakers to start thinking about a single portfolio management directive, let's say with product directives for UCITS funds, non-UCITS funds. We already have LTIFs, we already have money market funds, is ready to bring more harmonization here, because at the moment there does seem to be a lot of conflict. So MiFID II, third country, very helpful from a clarity perspective for certain aspects, but I think there's a bigger question that needs to be asked.